Welcome to MCM's Lunch and Learn series. Today's topic is practical copyright for creators. Today's speaker, Kathy Sade, is an entertainment attorney based in Bethesda, Maryland. She provides business and intellectual property law advice to producers, writers, musicians, and creative businesses through her law firm, Sade PC. She serves on the board of directors of Women in Film and Video in Washington, D.C. Kathy graduated from Harvard Law School and is admitted to practice in California, the District of Columbia, Maryland, and New York. MCM is excited to have Kathy as our speaker today. And with that, I will turn it over to her.
Hi, everybody. Thank you, Marcia, and thank you to MCM for having me. And hey, everybody from WIF. And I also have a few interns listening today, so hi, interns. So, as we were waiting to get started here, I was thinking a little bit about, why do creators need to understand copyright or appreciate copyright? And, at the end of the day, it is something that is, you just have to get right. If you want to create and have your work go anywhere commercially, anyone down the line is going to expect that you've dotted your copyright I's and crossed your copyright T's. So I applaud all of you for attending this webinar. So this first slide, this shouldn't come as a surprise to most of you. What is intellectual property? Basically, it's property of the intellect, things that you create with your mind. And that's distinguished from real property like a house or land or type of property. I think I have here a watch or a cow, something that you can actually put your hands around. Intellectual property is really a bundle of rights based on things that you've come up with intellectually. So 4 types of intellectual property. Again, not a surprise to most of you: patents, trade secrets, trademarks, and copyright. So all intellectual property falls into one of these 4 buckets. So just going back to that slide where that creator was thinking, so this is how things slot into the buckets. Patents are, inventions. Engineers come up with new ways of doing things, and that's what patents are. Trade secrets are, I always think of the formula for Coca-Cola, right? Secret processes that have commercial value. We're not going to be talking about patents and trade secrets today, or really trademarks for that matter, but it's important to understand how these differ from copyright. Trademarks, brand names, and logos, those are things that signal to a consumer the particular value of something coming from a certain source. And then at the end there is all the creative stuff, right? The sculptures, the paintings, the poems. So I just wanted to highlight here, this question comes up a lot. Well, I've got this great logo. Is it something I should trademark, or is it something I could copyright? Most of the time logos are trademarked, but theoretically you can copyright a logo. A logo is a design, right? It's an artistic creation. And if it's sufficiently unique, you could get a copyright on the logo. But typically, most of the time, they are trademarked. And then over here, we have something else I wanted to highlight. When it comes to music, there's actually 3 elements to music copyright. But if you think about the lyrics to the song, which are essentially, it's like a poem, and then you've also got the music itself, the musical composition. So both of those things can be copyrighted separately. And then, of course, once the music is performed, you have a sound recording and captured on a CD or whatever. So this is the key slide. If I do my job here today, you guys will understand this slide. And if you understand this slide, you will have a great framework for understanding copyright. So let's start at the top. The creative stuff is all that stuff in that copyright bucket: the poems, the music, the sculpture. Let's not overthink it for the minute. We'll just call it creative stuff. And as a creator yourself, let's look at this from the situation of you are, let's say, a documentary filmmaker, and you want to use other people's creative stuff in your own documentary. You want to use someone else's music, or you might want to use someone else's footage, or you might want to show a picture that someone took. That's someone else's creative stuff. So at this point, you've got a decision tree. First of all, is that stuff in the public domain? You've heard that concept before. We're going to talk about it later on, but let's assume it's not in the public domain. It is protected by copyright. It's either or. It's either in the public domain or it's protected by copyright. So if it's protected by copyright, because you've determined it's not in the public domain, then you've got 3 choices below. Directly below, you can license the content or you can buy it. And you'll see next to that little license or buy icon, I've got the Creative Commons icon there. And that's to emphasize that the Creative Commons, when you say so, oh, it's in the Creative Commons. For most Creative Commons content, that's actually still a license. There is one Creative Commons designation, CC0, which is, again, we're going to talk about that when we get to public domain, but by and large, the Creative Commons is a license. So I'm making a documentary film. I want to use some footage. It's not in the public domain. I say, okay, I'm going to license the footage, or I could even buy it. But, I probably just need to license it. What are my other options? Over to the left, fair use. And we're going to talk about this. I could fair use it if it falls in the categories of fair use, and we'll talk about the pros and cons of that. The other option I could do this, is I could infringe. I could say, I don't feel like paying for a license or figuring out who owns it, and it's fair use, I probably, but I'm just going to infringe it. I'm not going to spend a lot of time on that because if you guys were thinking that way, you probably wouldn't be attending this webinar. Don't do it. Just don't go there, because every step of the way, if you make something creatively that has some commercial value, every single step of the way, you are going to be promising people in contract, I did not infringe this. You're going to need, if you're a filmmaker, you might have to get E&O insurance. They're going to be making sure that you didn't infringe. It is just a dead end road if you start infringing. And that's why I chose that icon. That's where your content is going to go, or the potential success of your creation is just going to go downhill. This slide, it looks a little complicated, but let's go left to right. And I think you'll see it's pretty simple. We were just talking about other people's creative stuff. So we just go through that analysis and you figure out the right way to put it in your creative stuff. So that little bit of pink, the bottom of that blue column, that is, we creators, we stand on the shoulders of other creators, right? We're inspired by other people. So maybe you do want to license some content, or you think it's fair use, you can put it in your content. But once you create your stuff, the same, all's fair, right? Someone else can come along and want to use your stuff. And as a creator, you could decide to put it in the public domain, or you could say, no, I'm going to enjoy my copyright rights as a creator, but someone else could come along and fair use it or attempt to license it. And of course you can say no. So the cycle continues. That's really the point here. And the other thing just to add is, as a creator who wants to use other people's stuff, you might say, oh, that's such a, paperwork hassle. I'm really focused on framing or lighting, or why do I care about this legal stuff? The public policy reason behind copyright is that it's to protect creators, right? Because if you created something, if you spent, hours and hours of time and your great, creative mind, and you created something and someone else could just turn around and use it, like why did you just do that, right? If someone could just take it and run with it. So at the end of the day, this is actually all to protect you as creators. So what is subject to copyright? Again, this is probably most of you have heard this. I've said creative stuff, but it really is obviously more specific than that. Original works of authorship fixed in any tangible medium of expression, and that comes from the U.S. Copyright Act. So it has to be original. You have to have originated it. Authorship has to be human. You may have heard the story of the monkey who took the selfie, and there was some litigation about that. The photographer left a camera, the monkey found the camera, took this great selfie, and it was determined no, the person couldn't claim copyright in that picture because the monkey took it. It's kind of a cute story. I think the other example that comes up a lot is, you give an elephant a paintbrush and the painting, the elephant creates, no, that's not going to be copywritten. It's really quite interesting these days with artificial intelligence though, because if you plug some inputs into an algorithm, and the algorithm spits out a song, who created that, right? Did a human create that? So it's an evolving area of law. Fixed in any tangible medium of expression. For you painters and sculptors and filmmakers, that's not an issue. If you are an artist who works in chalk on sidewalks, or you build sand castles, or you're an installation artist, it's not permanent, it's not fixed in a tangible medium. So what a lot of people do will take pictures of this, transient art just to fix it so they can later claim copyright. What is not subject to copyright? Titles, facts, ideas, concepts, generic shapes, utilitarian objects. So I come up with the idea of a square. I'm not going to get a copyright for that. Facts, that's an interesting one. So facts are, things that happen. They're facts, and you can't claim copyright over that. So, an unlimited number of people could make a documentary about, Queen Elizabeth, for example, and they have. There's a lot of public facts about her. Now, the particular arrangement of those facts can be copywritten. So you can have a documentary that is purely fact-based, but the way the facts are selected and arranged is subject to copyright. And utilitarian objects, a hammer, things like that. Not gonna get copyright for that. So when is a work subject to copyright protection? So I've got 3 choices here for you. There's no actual voting, but just think about your answer. One is, when you come up with the idea in your head. B, when you write it down, you fix it. And then C is when you actually register it with the US copyright for copyright registration. And the answer is B, when you fix it, right? So this is a real misnomer, because people hear about copyright registration, they say, oh, I don't get protection until I've actually filed an application with the US Copyright Office. And that's sort of true, but it's sort of not true. Why would you register with the Copyright Office? Well, a couple things. Let's say I'm sitting here during this webinar and I'm doodling off on the side, and I happen to draw a beautiful picture of something, right? So I'm like, oh, look, I've created original creative expression. It's my design. Right then and there, copyright protects it. Okay, no one else can come along and just use it for their own devices. I've got the protection of copyright. But if I register that work with the US Copyright Office, a couple things happen. First of all, it puts the world on notice that I am claiming copyright. So someone could say, I think I want to license that design. Who owns it? And they can find it on the database. Second of all, it creates a presumption of ownership. So if I ever do get in litigation and I claim that someone's infringed my drawing, one of the elements of proving infringement is ownership. And essentially, by having the copyright, I will have a presumption of ownership, and the other side will have to prove that I don't own it. And then a couple other things, allows you to bring suit, and then you get the benefit of statutory damages, which are provided for by law if you've registered. So and there's timing elements there, which I won't get into. But one thing I would say, the question comes up, well, when should you register, right? Should I register? Let's say you're working on a script and it's a work in progress, right? Scripts are always evolving. Should you wait till it's done to register it, or should you register it? Maybe it's sort of done, it's a rough draft. I would say to you, when is it really ever going to be done, right? If you ask a creator, when is your work going to be done? There is always more tweaking you can do. I would say, look, if you've done something creative and you want to protect it with a copyright registration, but you haven't shown it to anybody, there's no need to register, right? It's just sitting in your house. It's not going out in the world. But if you do want to start sending it out in the world, and again, a script is a great example of this, just because people float scripts all the time. You want people to see your ideas and talk about it. And, maybe you show it to a producer, and the producer is like, hey, I think I can get a director interested in that, or some famous actor interested in that. You generally want people to talk about, get some buzz going. But at the same time, you don't want someone to, basically infringe your script and take it and run with it. So you might say, well, I know my script's going to change, but I think I'm going to register it. You can register it, and then you can register a later version. And I should add that the filing fee to register with the Copyright Office is really low. I think it just actually, in end of March, they just moved it from, I think it's $35 for a single original work to like $45. And, if you use an attorney to do that, there's legal fees involved. But it's not a big fee to register it. Okay, so what are these copyright protections I mentioned? There's 5 of them. You've probably heard this before. If you hold a copyright, you have and that's just, again, in my example earlier of I just sit here and draw a drawing, even if I haven't registered that as a work with the Copyright Office, I still have copyright just by virtue of fixing it, right? So the minute I draw my fancy drawing here, assuming it's original, I have these rights. I'm the only one who can copy it or distribute it, perform it, display, make derivative works. So performing, obviously, if it's a musical composition, people who do sculptures or make a visual art, a painting, there's no performance of those kind of static arts. And derivative works, what's a derivative work? I think my favorite example, because I'm a big Disney fan, is, there's this theme park ride called the Pirates of the Caribbean, right? It's a great ride. And someone said, hey, we should make that into a movie. So that's a derivative work, right? Another example, would be, you see it all the time, the movie spins off the Broadway show. It just, goes on and on. So that's a derivative work. And copyright protections are not forever. For an original work that, one person just kind of dreams up on their own, the protection lasts for the life of that author plus 70 years. And we're going to talk about how that can be different depending on who the author is. So that's what you get. So copyright is really like a bundle of rights that protect your creative content. So going back to this is that slide I talked about. This is the one I want you guys to understand. So you're creating something and you decide you want to use someone else's stuff that's protected by copyright. It may be registered with the Copyright Office. It may not be registered with the Copyright Office. Doesn't matter. You now are at this decision tree below. Do I fair use it? Do I license or buy it? Or do I infringe it? And you're not going to infringe it. So it's really, let's look at license or buying first, because that's really where most of this shakes out. What I like to explain to people in terms of copyright, it's like a car, right? You can either buy the car and then it's your car and you can do whatever you want to it. It's your car. Or you can rent the car. And when you rent a car, there's conditions attached, right? You can only drive it, maybe in the United States. You've got to return it with a full tank of gas, whatever the conditions are. So when you purchase a copyright, you're buying the copyright. And we lawyers call it assignment of copyright or transfer of copyright. You don't see like a sale of copyright agreement. So typically a copyright assignment agreement. And I have this little icon with the 2 people shaking hands because it's like any commercial transaction, it's up to the buyer and the seller what they want to do. A lot of times people, let's take a script as an example. If a producer buys a script, right? They're buying the script, obviously, but are they also buying, say, the derivative rights? Can they make prequels and sequels, spin-offs? Can they do merchandising? Can they make the theme park ride out of the script? So you have to obviously always read all your contracts every time, but read what you're actually selling here. And then I always find it interesting that in a copyright assignment agreement, there's always some language that says, by the way, hey seller, you have to really cooperate in the sale. We might have to come back and get you to sign some odds and ends of papers to affect the sale. If the copyright being sold was originally registered with the Copyright Office, there will be a filing that basically changes that record to say that the copyright has now been sold to somebody else. And if the buyer disappears, if the seller of the copyright disappears, the buyer usually gets a power of attorney to I can't find the person and I need to file this form, so I'm going to sign. So it's sort of an interesting document. Maybe I'm being a little bit of a geeky lawyer, but anyway. And one important thing, this is really important for all of you, is that when you do a copyright assignment agreement or transfer agreement, it has to be pretty formal. It has to be written and it has to be signed. So none of this, we met over coffee back in the days when we could meet over coffee and we decided, yes, we'd sell it. No, it has to actually, you have to write it down and sign it to be a legal transfer. All right, so most of you guys are not going to be buying copyrights. You are going to be renting them. You're going to be leasing them. And anyone who's ever dealt with a copyright license has seen some of these terms, a perpetual, irrevocable, exclusive license. What I've tried to do is put in parentheses what that means in, regular everyday terms. A perpetual license is forever. Irrevocable means the person granting it can't turn around and say, yeah, no, I want it back. Exclusive means only the person getting the license can have it, no one else. A non-exclusive license can be licensed to many different people. So I've listed those there. So let's talk about Creative Commons. Every license is unique, right? It's up to the buyer and the seller, the licensor and the licensee. That's why I've got my little handshake icon again. It's private contract. What Creative Commons has tried to do, and it's a great service, is say, look, rather than reinvent the wheel every single time, let's set out certain types of licenses that are commonly used. And there's, I think, 6 of them. They're permutations of these 4 concepts, which is you're not going to use it for commercial use, or if you use it, you have to attribute the author of the work you're using. So again, think of Creative Commons like a license. You should read it. There's actually a license agreement. It's like a legal document. And you do have to follow the terms of the Creative Commons license. So the last category there, as I said, it's a matter of private contract of what the license says. You can have all sorts of conditions. And again, this is probably not new to any of you, but these are why, you need to read your license and see what you're agreeing to. And I get kind of cute at the bottom, only if you use it while wearing a purple sweater. Well, someone could maybe make that a condition of their license. And then my favorite is only if you agree one day, if you meet the author, to buy the author a beer. That is actually called the beer license. It is used in open source software, which we won't talk about technology and software, but open source is people creating code and then letting people use it. And there's all sorts of different licenses, but this beer license, this one guy created some code and he said, I'll license it to you, but if you ever meet me and you think my code was helpful, buy me a beer. So that's the terms of his license. So what if you get a limited license? What does that mean? I don't know what that means. Limited? I don't know. It's a word that comes up a lot in legal documents, a limited license. Well, limited how? Jurisdiction, time, you have to wear a purple sweater, what, so don't, when I see the word limited, I kind of just skip over that. Like, okay, they're trying to do something. I'm not really sure what it is. And I look for the specific, for a period of 5 years or the details. So I just thought I'd throw that in there. Okay, so some of this we've covered. Creative Commons is a license. I did mention the CC0 or CC0. That is basically, let's say I create something, I do this drawing while I'm sitting here talking, and I say, this is so great, but I want to just put it out in the public domain. I don't care about it. Let other people use it. Well, how do I do that? And Creative Commons has a form. It's actually not a license. It's essentially a waiver that you can apply to that work. And that essentially is how a creator would put something in the public domain. Talked about reading the license, understand what your scope of the license is. Again, always get it in writing. Legally, I think if it's an exclusive license, you have to get it in writing. But even for a non-exclusive license, people are going to, and again, anyone downstream who's using your content or wanting to distribute the content or commercialize it is going to want to know that you had your ducks in a row. So just, get your licenses in writing. A click-through agreement typically is a license. So, as you're clicking through, stop, print out what you've clicked through. It is very frustrating for us lawyers to say, hey, what did you get a license? Well, yeah, I clicked something. Well, what was it? Having to go back and find that can be challenging. It never hurts to ask. So when I'm not being a lawyer, I'm actually working on a tiny little documentary film, just really a hobby project. But I was talking to my dad about it, and he's like, there's this great song called the Anvil Chorus that would go really nicely with your documentary. My documentary is about horseshoers, people who put shoes on horses, and the anvil is an important tool for these folks. So the Anvil Chorus, wow, that's great, Dad. And I thought, well, I'm never, licensing, something that's on a CD somewhere, but, it's just a hobby. I don't have any, I don't want to spend a lot of money on it, but I'll find out. I think it was like $300. I mean, which is money, but, for one song, I was like, wow, that's okay. So it never, I guess my punchline here is, if you want to use something, if it's a big company, Disney, yeah, the license fee is going to be probably significant, but a lot of people are happy to license their work. It may be for a de minimis fee. If it's another independent small creator, they may be thrilled to license it just to get the attribution, the exposure for their own content. So, I would say it never hurts to explore how much the license might be. Now, I'm my little dragon icon here. This is the challenge. What if you can't find the owner? Like, you're like, okay, I want to do the right thing. I want to license it. I'm willing to pay, a reasonable amount of money or give attribution, but who do I go to? How do I do this? That, I would say, can be one of the biggest challenges, is finding out who owns the copyright. And especially because copyright can be sold, right? As we just talked about a few slides ago. So that is where I would tell everyone, you sort of have to persevere and become a detective, right? You can check the Copyright Office. They have a database of copyright filings. If you've got a book or, a composition, sheet music, look, is there a copyright notice on the music? For music, you can look at, BMI, the different PROs, Harry Fox. I mean, you sort of have to kind of look around. And what if you, really try and find something and you can't find the owner? You still, if you use it and then the owner kind of comes out of the woodwork, you could still have liability for infringing. So it's tough because, some people make it really easy to license content. If you go to, one of the stock footage companies, I mean, they make it really easy, right? Or newspapers, you want to do a reprint of an article. I mean, click, and you can do it. But that's not always the case. So you kind of have to slay the dragon, is kind of the point of that little icon. You have to sometimes do some work. All right, so let's talk about fair use. I picked the little icon for fair use. It's kind of vague and undefined, and it's got a lot of sharp points, and that's sort of how I think about fair use. Here's something everyone should know. Fair use is not like this sketchy thing, No, it's part of the Copyright Act. Congress intended it to be used. It's built right in there. And most of you have heard about the 4 factors for fair use. You can fair use something. These are the factors that courts will look at. The purpose and character of the fair using. What was the nature of what was being fair used? Was it a news broadcast that's sort of cut and dry? Or was it really creative? And I'll talk about that in a minute, but let me go back to this concept of fair use, just big picture. Copyright gives content creators exclusive rights to their stuff. At the same time, we've got free speech, right? So there's this tension of, and I think of fair use as sort of like the little valve that lets some steam escape. You want people to, going back to that one slide, stand on the shoulders of other creators. Everyone's inspired by something, and fair use allows you to bring in other content. However, it really has to be the way the courts have interpreted these 4 factors. I mean, and again, this is not new to most of you. What you need to be doing with that other content is really transforming it into something that is standing alone, original. It changes the fundamental nature of what you've done. And it can't be simply a substitute for the original work. So let me use an example. I haven't seen this documentary, but someone did a documentary about The Shining, the movie The Shining, based on Stephen King's book. And he used a lot of The Shining in his documentary, or her documentary. And relying on the fair use doctrine. It was a critical analysis of that movie, of The Shining. And no one would watch the documentary to say, I want to be entertained. I want to watch this documentary about The Shining. It jumbled up the story. It wasn't like you watched the linear The Shining. Now, what if I decide, people are busy these days. They don't have an hour and a half to watch The Shining. I'm just going to edit it down so someone could watch it in 15 minutes and sell it as the condensed guide to The Shining. That would be infringing. But if I, like this other documentarian libertarian did, really transformed it into something that was new and unique, then that could be fair use. So I guess just to, trot through this, the first factor there, the purpose and character of the use, that's really, I think, where the action is here these days with fair use. Did you transform it to make it something unique? And there's a great well-known entertainment lawyer, Michael Donaldson. He explains it this: did you use the other content to make a point, and did you use only enough of it to illustrate your point? And I think that's a great way of thinking about it. For example, my documentary, there's one scene where it's actually a little different. There was a scene where one of my subjects was doing something, and there was some music in the background, and it just happened to be playing. And I don't want to alter reality in that particular scene by taking out the sound. So I have the scene, but I just stopped it wherever, the content I wanted to use ended, and it kind of ended in an awkward part of the song, but so be it. The song was sort of in the background. I had to use it for the scene. What I would tell everyone, if you're a filmmaker, a documentary filmmaker, the statement of best practices and fair use, the last bullet there, is really a phenomenal resource that talks through the different ways that content can be fair used in documentaries. I mentioned, just part of the background scenery was the case in my film, or, if you're doing a critical kind of analytical documentary, you're using it to make a point, as the earlier comment was. There's also, but let's go from the top. There's a fallacy out there, if you only use 10 seconds or whatever. No, that's not the case. And usually, when people talk about fair use, if we had all the time in the world, people go through the court cases because it is so fact specific. And, well, in this case, this was used and this was done and the court ruled this, but in this case, it is really, really fact specific. And there's really there's no bright line or safe harbor. If some content creator is aggrieved and you say, well, I fair used it, and, I only used what I needed to, and they could still bring an action, and you're not going to have any certainty on whether you can rely on the fair use doctrine until, the gavel comes down, is sort of how people think about it. It's, what the jury says or what the judge says. So there is some risk to it. But at the same time, going back to what I said, it's in the Copyright Act. It's okay to fair use. The challenge is it may not always give you as much certainty. So best practice is not to try and fair use in trailers or promotional materials if you're making a film. And, I talk about fair use in documentaries. Documentaries can be very commercial these days. I mean, there's a lot, three identical strangers, RGB, RBG, sorry. There's some really great documentaries out there that have had really great commercial success. So it's okay that they have commercial success. Those documentaries used other footage. Now, did they fair use them, or did they go and try and get licenses? So this is this third bullet. Because there's this uncertainty with fair use, you can go and try and get the license, and then you've got a piece of paper signed, you're good. But if the person says, no, I don't want to license it, the courts have said you can still fair use even if you've tried to get the license and haven't succeeded for whatever reason. So I always like to point that out. Attribution does not cure copyright infringement. It may be required if you're using a attribution copyright Creative Commons license. It might be a condition of that particular license, but sometimes people say, well, I'll just give them credit. Well, no, that doesn't solve the fundamental copyright issue. Having said that, if you're fair using, it's always a nice thing to give credit when fair using, but you shouldn't say, thanks to Disney or whoever, whatever source that the content you're fair using comes from, because that could imply that they gave permission and they didn't, right? And then one other point I just wanted to throw in here: fair dealing. it's a very related concept to fair use, and there's just a different term that's used in the United Kingdom and Canada for fair use. So if you see fair dealing, that's a very similar concept. All right, I'm moving quick here. There are entire webinars devoted to fair use, but I think that's the highlight there. And I would say, it comes up a lot for documentary filmmakers, also attribution artists. You take something famous and then you tweak it to put your own spin on it. Those are the folks I think who think a lot about fair use. And one other thing I will say here, it's interesting. Fair use in music is a whole different animal. You probably heard about the Katy Perry litigation. There were some beats that maybe came from another song, and that's been litigated. It's interesting how different fair use is applied. So I would not recommend thinking expansively about fair using other people's music, because that has not gone well for musicians. Perils of infringement, this is the third theoretical option here. Just don't do it. Whether you are optioning a script to a producer, whether you are a musician who's recorded music, anyone you do business with is going to make you sign a representation saying, hey, author, hey, person I'm doing business with, you promise that you own all the rights, title, and interest of what you're about to give me, either because it's original to you or you've obtained authorization. Nobody wants to take on the risk of copyright infringement. So they kind of, before they do business with you, they're going to make you promise that you haven't infringed. So again, it's worth it to get your ducks in a row. And doing it early is much easier than going down the line, creating your content and then realizing, oops, I've got a copyright issue. And then, you have to give it back to your editor to lift out segments, or you have to, wind it back what you've done. And that's unfortunate. So copyright is something that should be thought about early in the creative process. Public domain. Okay. So, let's go through kind of the nuts and bolts. Public Domain Day now is January 1st of every year. If things are old enough, they will be in the public domain. And so that's currently anything pre-January 1, 1925. And there's websites that'll tell you what's coming up. So if you're looking for public domain things that are coming up January 1, 2021, I'm sure people are putting together lists of things that will be in the public domain. You've heard that U.S. government works federal government works are in the public domain. That's usually the case. I took a really interesting class, National Archives, tons of government materials. And even though it's at the National Archives, not everything there is in the public domain. So you still have to be a little careful with U.S. government works, but they're usually in the public domain. We talked about creators who voluntarily place content in the public domain, usually by the Creative Commons 0 waiver. Sound recordings typically are not in the public domain. And one thing I should have mentioned, the copyright laws, there was a lot of change depending on when something's created, different rules apply is sort of what I'm getting at. So the law started changing in the 70s and the 80s. And depending on when something was created, there might have been a notice, actually putting the copyright notice on it requirement, or you have to renew your registration. And it's really complicated to explain. And there are lots of resources out there. I love the Public Domain Sherpa website. Now, I'm not saying it's accurate. I can't vouch for the accuracy, but it has a lot of great tools there. If you are trying to figure out, well, is this in the public domain? There's a calculator, there's a flow chart. So it's a really good resource. I would also say the U.S. Copyright Office has phenomenal resources. If you want to better understand anything I've talked about, there's the Copyright Office Compendium, which is a document. It's designed for people who work at the Copyright Office in evaluating registrations, but it's publicly available and it's pretty readable, and it gives examples of things that have been approved and haven't been approved. So there's a lot of resources out there to kind of sort through all this and educate yourself. And then lastly, something can be in the public domain here in the United States, but not in other countries and other jurisdictions. Okay, so remember Frankenstein. This is the important thing about public domain. So Mary Shelley, I was looking this up right before the webcast started. Mary Shelley wrote Frankenstein, her book. She's 20 years old, and she wrote it in 1818. So that's really old. The book is in the public domain. Well, along comes Universal Studios in 1931 and creates Frankenstein the movie with Boris Karloff. And Mary Shelley's Frankenstein, in the literary work, had a description of the monster, but it didn't say anything about green skin or bolts on the side of the monster's neck. And when Universal made their Frankenstein, they put some green makeup on Boris and the bolts. And so let's say it's now 2020 and you want to make something with Frankenstein, and you say, well, Frankenstein's in the public domain. So your creation has the green skin and the bolts. And, you hear from Universal Studios saying, hey, you've infringed, right? This is the point. The stuff that's in the public domain is in the public domain, and what other people have done with that may be copywritten. So same thing, Snow White is the other example I hear about. The Grimm brothers' Snow White in the public domain. Disney's Snow White with the characteristics Disney gave that character are not in the public domain. So just be careful about that. Who's the author? Let's go through this quickly. If I sit in a room, my example here, I've drawn something, I am the sole author, it's mine. Now, when I've created it, I, Kathy Sade, am the author. But let's say I have big dreams for my media empire and I decide to create, Sade Media Productions, LLC. And the first thing I'm gonna do is do a line of t-shirts with that design produced by my new LLC. I need to actually transfer my copyright from myself as an individual up to my entity. Okay, that would be the copyright transfer agreement, the copyright assignment agreement to your entity. So just a little pointer there. Joint authors. When two people get together and they both contribute copyrightable work, so not just an idea, which is kind of not fixed, it's just an idea, but actual copyrightable work. And at the time they make that contribution together, they're intending it to be merged into a joint work. Then they become joint authors. And we're going to talk about this a little bit because I do see this come up. So when people are joint authors, they both have the right to run off and cut deals, as long as it's not an exclusive deal. So an example, if you read about this, the example that people gives, one joint author is, talking to like a big distributor, Netflix, Warner Brothers, some big, great distributor they would love to get. And then the other one is over here talking to like a smaller production distributor and makes the deal here. And then this person's like, what have you done? That's the perils of joint authorship. Either person can unilaterally go off and cut deals that are not exclusive. Now, if this person cuts the deal, they have to, any profits from that have to be shared amongst the joint authors. It's not like they get all the benefits of that. But, this person's like, hey, I was this close to striking my big deal, and now, you've undercut it by this one. The point here is if you do have a joint author situation, you can preempt all that by entering into a collaboration agreement that says, hey, we're not going to cut any deals unless we all agree. And then you've got everyone's on the same page. Copyright transfer, we talked about that. This could be a situation where two people are kind of thinking about something, but the one person has already kind of, created the copyrightable work. So they're not merging it at the time of creation, but the other person says, hey, I'd kind of like that for my thing. You can do the copyright transfer there. Work for hire is really important for you creators because a lot of times you will want people to help you. You're a musician. You might have studio musicians come on and play some parts. You may be designing something and you need an illustrator. Anyone who helps you, when they write write their, say you hire an illustrator. If you don't do it as work for hire and they just draw, you say, hey, draw me this, and they draw it, it's theirs, right? Because they're the original author of that content. But if you do a work for hire, as they're drawing, as I always say, as the ink is flowing out of their pen, the results of that belong to you as the author. So how can you be a work for hire? There's one of two ways. They can be your employee. And a lot of independent creators don't have employees. You're not running a W-2 payroll, So for a company, yes, that's their employees if they're doing it within the scope of their employment. So again, I'm using Disney as an example. They have illustrators, right? Animators, excuse me. Those animators, they are employees who are paid to animate. Everything they do belongs to Disney. But for independent creators, who I presume are on this webinar, then you're talking about independent contractors, 1099s. And for those folks, the interesting thing is that the Copyright Act allows work for hire, but only for 9 categories of things. Now, movies are one of those 9 categories, or audiovisual works are there. But other things aren't. Literary works aren't. And there's some weird catch-all categories like collaborative works. So what people will do for a work for hire in that situation, they'll say, hey, I'm going to hire you pursuant to this contract as a work for hire, and anything you do is going to belong to me. But just in case that doesn't work out, we're also going to bake in a copyright assignment. So just in case the work for hire doesn't work out, you're automatically assigning that stuff to me. And I won't go into detail here, but why you might want to think about doing a work for hire is that the timing is a little different from the original authorship. Real quick on takedowns, everything I've said, that's like the copyright basics. So a lot of content creators will put their content on YouTube and all of a sudden get a notice from YouTube saying, hey, we've received a takedown notice because your content may include content from someone else's. Why is YouTube doing this? It's a Digital Millennium Copyright Act, I think I'm saying that right, DMCA, provides some liability protections for YouTube so they don't get accused of, they don't have liability for contributory infringement if they issue these takedown notices. So that's why they're doing it. Lastly, the LLC, Sade Media Empire LLC, let's say I own that company, but I've infringed. Just the fact that I have an entity doesn't shield me from personal liability for infringing. So just don't think that just because you have an entity that you don't have to worry about infringement. I've talked about the sub-creators. You don't have to include a copyright notice if you are claiming copyright, but it's a great, I would just recommend doing it because it puts people on notice like, hey, I take this seriously. And I've mentioned about the resources. So with that, I better hand it over to Marcia so that we end on time. Thank you, everybody. And my contact information is at the end of the slide. Thanks, everybody. Take care.
Thank you, Kathy, for sharing your expertise today. And thank you for attending today's presentation.